I'm Judge Ashley Wilcott. We are in verdict watch in the scattered remains murder trial of Daniel Stearns in Florida. The jury has now been deliberating for about 5 minutes. We've put the clock up on your screen, and he does face up to life in prison if convicted of killing his girlfriend, Nancy Howery, and then dismembering and burning her body back in February of 2023.
Now, Stearns initially told police that they broke up and that he hadn't seen her in weeks. And then later he claimed that he shot and killed Howery after she lunged at him during an argument. However, the judge ruled that that confession could not come in at trial. The jury never heard it.
That's right. Now, during testimony today, the state showed these jarring and powerful images of the hundreds of bone fragments recovered from the burial site. They are all that was left of Nancy Howery.
Now, after testimony ended, the state rested and the defendant told the judge that he would not be testifying in his own defense. So we're catching you up on closings as we await a verdict. Let's head back to court.
The death of Miss Howery. What's missing that makes the difference between second-degree murder and manslaughter is that it was eminently dangerous, or the evil intent element. Okay, that the act was done from spite, ill will, hatred, evil intent. That's not in manslaughter. It says every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is just negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable, like we talked at the beginning, self-defense, or excusable, an accident under those circumstances we talked about. In order to convict of manslaughter by act, it is not necessary, again, for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not negligent, was not justified, and was not excusable, and that act that he committed caused the death. So again, just like second-degree murder, it doesn't have to be premeditated. No, we don't have to prove that he was trying to kill her, just that he did something, and that something was not just negligence. It was more than that. So shooting someone in the head is more than just negligence, and that act is what actually caused the death. Again, you'll get that, like I said, for manslaughter, there's an aggravation. The firearm is used as well. It'll be that same instruction we talked about before, but it'll say manslaughter instead of second-degree murder. You'll get an instruction on, and the judge might have read some of this in our jury selection process, weighing the evidence, okay? It's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. Your job as a jury is to judge the facts. You should consider how the witnesses acted as well as what they said. And this gives you some ideas of ways to weigh credibility, but it's not an exclusive list. Obviously, you use your common sense. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? And did the witness at some time make a statement that is inconsistent with the testimony he or she gave in court? So all of those things you would apply when looking at all the witnesses that testified, and even you can apply it to looking at the evidence that you have. You know, is the defendant's statement in those interviews consistent with the rest of the evidence that you have? Is it consistent with seeing him on the clock, cameras, or with what the other testimony was about Ms. Ramos saying they were planning to meet up that day, and so forth. You can compare all of that stuff together. You'll also get part of the instructions that say this: you must follow the law as is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice, and there is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in these matters. Again, this is another place where it talks about how you should go about determining your verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes that the evidence may justify or not guilty. If you return a verdict of guilty, it should be the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict would be not guilty. Your verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. You have 3 crimes in this case, so you'll have 3 verdict forms, and they will look like this. The first one, we, the jury, find as follows as to count 1 of the charge, and it tells you to check only 1. You all have to agree on which one. A is going to be the defendant's guilty of second-degree murder with a firearm. B would be the second-degree murder minus the firearm. C would be guilty of manslaughter with a firearm. D would be manslaughter, no firearm. And then E would be not guilty. And then the rest of that form has another special finding, which seems kind of redundant, and it is, but it's just to make sure that every verdict is consistent. It says, in addition to the verdict form for that count, there's a special finding form for count 1. It'll all be on the same piece of paper when you get it. If you find the defendant guilty of either second-degree murder or manslaughter, you must answer the following question. And the question is going to be the aggravation for the firearm that we talked about before. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? And then you would check yes or no. Okay? The other 2 forms are pretty straightforward. There are no lesser included offenses, so you either have an A or a B. Guilty or not guilty of abuse of a human dead body. And the same thing for count 3. Guilty or not guilty of tampering with physical evidence is A or B. So I thank you all very much for your time and attention. Mr. Fisher is going to speak with you, and then we'll have a short rebuttal.
Attorneys approach for just a moment.
Go ahead.
You know what's interesting, and we're just going to hold on here while the defense gets ready to deliver their closing argument, is, you know, all you can really ask for as a defense attorney in the system is for the prosecution and the investigators to do their job. One thing that jumps out about this case to me is, as you laid out the elements, this was a case where they did their job. The investigation was strong, solid, and tight, and as a result, you got a strong, solid, and tight case.
And then add to that, my question to you was, are you surprised that they're also giving the jury the option of manslaughter? And I think that, number one, for the defense, I think that's how they hedge their bets and say, if you have empathy or compassion for this defendant and don't want to go with the second degree, then that's an option as well.
Because no one was there. No one knows what really happened.
Exactly. It's true, but circumstantial evidence is pretty good. All right, let's go back in. The defense is beginning its closing argument.
Ladies and gentlemen of the jury, it's been a while and I haven't addressed you directly since jury selection. And the core issue of this case is what happened? What happened in this case? And the answer is, you don't know, because the state hasn't given you evidence as to what happened. And what they're wanting to do is have you start filling in gaps and making assumptions and just sort of assume their way past the requirement to prove this case beyond a reasonable doubt. One of the statements the state keeps saying is he shot her in the head. You've heard no testimony that he ever shot her in the head. You've heard nothing about him shooting in the head. You've heard that there is what Dr. Walsh-Haney says is consistent with a gunshot wound, a gunshot exit wound, but not that he ever did anything. Not a single witness has ever said that he shot her in the head, because it's consistent with her shooting herself. It's consistent with an accident. It's consistent with any number of other events. And the core problem here is that the the state must prove what happened. And they haven't done it. So if you go through the evidence, there is a presumption of innocence. The court will tell you the defendant has entered a plea of not guilty. This must mean you presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it's been overcome by the evidence to the exclusion of beyond a reasonable doubt. And it hasn't happened. So what's reasonable doubt? Yes, proof beyond a reasonable doubt is not proof beyond all doubt. But a reasonable doubt is not a mere possible doubt or speculative doubt. But if after comparing and considering and weighing the evidence, there's not an abiding conviction of guilt, or it's one which wavers and vacillates, the charge is not proved beyond a reasonable doubt as to every single element. A reasonable doubt that the guilt of the defendant can arise from the evidence, conflict of the evidence, or in this case, the absence of evidence. And there is a very clear absence of evidence in this case. They keep talking about, well, he got together with her, and then they say, and then they didn't hear from her, and then he's out there, and they follow him, and he's clearly involved in cremating the body and scattering the ashes, therefore he must have killed her. No, that doesn't follow. He knows she's dead. He clearly cremated the body and scattered the ashes, but that doesn't mean he had anything to do with her death or that he caused it or that he shot her. What's missing in this case is anything about Miss Howery herself. You've heard that she's divorced, but you don't know why she's divorced. You heard that she doesn't have a regular job. She buys and sells stuff on the internet. You know that she's been arrested. You know that she's been convicted of stuff. You don't know anything about her temperament. You know nothing about her. And the state has never talked about it. They've never discussed it. They've never presented evidence on it. You don't know what her temperament is like or what she's capable of. You know nothing.
We need to take a break here, but first, we are tracking CourtTV's newest live trial, the toddler fatally stabbed trial in Ohio.
Bianca Ellis is accused of stabbing 4-year-old Julian Wood while his mother was pushing him in a shopping cart in the parking lot of a grocery store. His mother, Margot, was also attacked, but she did survive.
After a jury was seated this afternoon, opening statements got underway. Here's a part of the state's opening.
Bianca Ellis coming in to Giant Eagle, and she's got the 12-inch butcher knife. And she has it right by her side, and she's walking, and she's walking. And you will see in the video, ladies and gentlemen, that Margot had paid for her groceries. She had her hanging basket on her cart, the child in the seat of the cart, walking out, going to load her groceries and go home. I want you to pay attention to the video. As Mrs. Wood is walking out with Julian, and they're actually having a conversation, Miss Ellis passes them going this way, for lack of a better word to describe. She would be going west, and they are coming east. And so therefore, she sees them walking, and she turns immediately around. And she follows them all the way out of the store. And you will see that she is walking in tandem with them. There'll come a point in the video where you will see that she is walking faster, so she passes them. She stops, waits for them to catch up, and follows them completely out of the store.
Now, the defense is claiming she's not guilty by reason of insanity. We'll hear from the defense attorney a little later in the show, and we'll bring you full coverage of opening statements coming up in our next hour.
We need to pause it right there for a break, but we will get you back to closings when Court TV Live returns.
Also in Massachusetts, the murder trial of Brian Walsh, which is set to begin later this month, has now been delayed. We'll have details there.
And as former NFL quarterback Mark Sanchez recovers from stab wounds, he learns that the charges against him just became more serious. Keep it here on your front row seat to justice.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Marcel ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands. New episodes Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Before we get you back to court, we want to update you on some other cases that Court TV is tracking. In Massachusetts, a judge is moving a civil case against Karen Reed closer to trial after refusing to dismiss claims of emotional distress against Reed. John O'Keefe's family filed a wrongful death lawsuit against Reed after she was acquitted of killing her boyfriend, John O'Keefe, last year.
Also in Massachusetts, Brian Walsh's trial is being postponed after a judge ordered that he undergo a mental health evaluation. This comes less than a month before Walsh was due to go on trial for the murder and dismemberment of his wife, Anna.
In Indiana, former NFL quarterback and current analyst Mark Sanchez is now facing a felony battery charge following his arrest for his role in an altercation early Saturday morning. According to the affidavit, Sanchez got in a dispute with a 69-year-old truck driver over a parking space. Sanchez was seen throwing the driver against a wall, and when he continued to advance toward him, the truck driver stabbed Sanchez.
And in Texas, Darren Brown was sentenced to life in prison after pleading guilty to murdering 4-year-old Cash Gernon moments before his trial was set to begin. After being sentenced, the victim impact statement from Cash's grandmother, who was also the custodian to Cash's surviving twin, was read to the defendant.
Every single day, I imagine what Cash would look like and what it would be like for his brother to have him here. We suffer from your disgusting, hateful, and horrid act of violence every single day. Again, the pain of what you did won't ever go away, and if I had it my way, you would never see the light of day again, and you would suffer the same fate that you have brought on Cash.
And now let's turn back to Florida for more of the defense's closing argument in the scattered remains murder trial of Daniel Stearns.
Nothing. The court will instruct you the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. You'll also hear that the killing of a human being is excusable and therefore lawful under any of the following three circumstances, and I'm just going to talk about the first two. When the killing was committed by accident and misfortune during a lawful act, by lawful means with ordinary caution without any unlawful intent, or two, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. You don't know anything about what happened, and the state has to prove this case beyond a reasonable doubt, and if it's a justifiable homicide or excusable homicide, it isn't proven beyond a reasonable doubt. And you don't know. And once again, a reasonable doubt can arise from the absence of evidence. And there is an absence of evidence. The state keeps talking about circumstantial evidence. Okay. Essentially, they want you to conclude that because she was going to get together with him, and remember, she called him. I elicited that testimony on the analysis, right? The only person that ever called anybody was she kept calling him. Every call they had out of her phone, out of his phone, is her calling him. Now, granted, they could be communicating by internet, but you also heard from Ms. Ramos. Her battery was dying, so she'd charge it up some, and then she'd call again. And that's consistent with the testimony. He's not planning to do anything, because he's not planning on getting together with them. They say they argued, but that's not what Ms. Ramos testified to. She said that they just kept talking, off and on, for over a course of like an hour. And eventually he agrees to get together with her, and they're supposed to meet somewhere else. Her car, it was abandoned. It was parked normally on the side of the road, and she obviously got out of the car and joined him, and then they went off to the compound because that's what they'd agreed to do. What the state keeps doing, can you make this darker? Yes. Okay. There we go. All right. I'm going to do this like a math problem. 1, they knew each other. 2, they get together. And 3 and 4, he's out there and he's clearly burned the body, cremated it, and scattered ashes. And then they want you to assume the next 4 blanks. And the state.
Oh, no.
All right, let's bring in our guest for this hour. Joining us to discuss is criminal defense attorney Silva Megadichian. Silva, great to see you as always. Thank you so much for joining us here on the program. And the one thing I want to say is, and I said this to Judge earlier, as a defense attorney, you know what you do is in a case like this where the evidence is really against you. You just have to challenge every piece of evidence. And you hope for a weak investigation, some holes in the investigation. This is one of those cases where that doesn't even exist. I mean, they followed this guy, and they watched him do certain things. I mean, this is a tough one to wiggle out from under.
Oh, Michael, there's no doubt. First of all, my dream team co-anchors, I adore you both. Thank you, Judge Ashley and Michael, for having me. Look, fist bump, Judge Ashley.
We'll take it.
What I love about what this defense attorney did, and Michael, you said it right before the defense's argument. You said this is what prosecutors do. It's a black and white argument. They stuck to the facts. There was no theatrics. She was incredibly matter of fact because they have a beautiful, well-rounded investigation. Sure, the confession was tossed out, but it doesn't affect the strength of their case. Their case is so strong because of so much of the evidence corroborates the confession that they really didn't even need it. But I love what the defense attorney said. He said, what happened? We don't know. And for a very critical juror, this could open the door to maybe the jury discussing, well, maybe it was a fight that went wrong. In other words, maybe he was trying to do some kind of self-defense, but then another discernible juror is going to say, even though he has the right not to testify, the easiest way to show this is he should say his side, but he didn't. So that reasonable doubt becomes a little unreasonable, doesn't it?
So,
but
Silva,
I do think the defense attorney...
I'm sorry, I didn't mean to interrupt you, but I just have to ask you a question at this juncture, because what stood out to me is I felt like the defense attorney, although I find him charismatic, likable, presenting a great closing argument, was simply defining circumstantial evidence. This is a circumstantial evidence case. They don't have a witness who saw it happen. So I felt like, if that's the best you have, it may not play well.
But Judge Ashley, I think in the desperation sometimes of defense attorneys, when we really don't have something viable, we use the best thing we can. If attacking circumstantial evidence is it, then we have to do it. The evidence was incredibly bad on this client, right? And if I put myself in the defense attorney's position, and literally when CourtTV gives us the eyes into these trials, that's what I do. I try to imagine what I would argue. And I was kind of proud of this defense attorney for actually doing this kind of argument, because I don't know what else he could have said that is reasonable. Remember, it's not all doubt, it's reasonable doubt. And I just don't see reasonable doubt in this case without attacking circumstantial evidence.
And the way you present it is so key, and I think he's presenting it very well.
Yeah, and they're considering it. They've been out now, as we can see, about 33 minutes or so. We're kind of all expecting this one to be a relatively quick verdict, but you never know. We've been surprised before. All right, Silva, stand by. We're going to take this opportunity to squeeze in a break. The defense wraps up its closing argument when we return. Keep it here on CourtTV.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We'll get you back to court in just a moment. But first, we do want to update you on Court TV's newest live trial that's coming out of Ohio, the toddler fatally stabbed trial of Bianca Ellis. Now, she's accused of stabbing 4-year-old Julian Wood to death in a parking lot outside of a grocery store back in May. He was still in the grocery cart when the attack happened.
Ellis had claimed insanity, but the court ruled she was competent to stand trial. We heard some of the prosecutor's opening statement earlier in this show, and now we'd like to hear a little from the defense.
And it is true that whatever's going on in her mind, whatever's going on with her mental illness, the evidence will show that she got behind Ms. Wood and her child, Julian, and she followed her. And she doesn't run away. She walks away. Knife in hand. Still carrying the knife after this act is done. The evidence will show that there was no rational motive for her to have committed this offense. The evidence will show that there's no relationship between she and the victims in this case. She still has a knife in hand at the time that the police confronts her.
We will have more of the opening statements from both sides coming up next hour.
All right, folks, let's head back to Florida now, where a jury is deciding the fate of Daniel Stearns in the scattered remains murder trial. Jurors have been deliberating now for about 40 minutes or so.
Stearns faces up to life in prison if convicted of killing his girlfriend, Nancy Howery, back in February of 2023. Right now, we want to get you back into court, where the defense is wrapping up its closing argument.
You had Dr. Walsh-Haney saying, well, I think there's some blunt force trauma to the left side of the head. Okay, well, there's asphalt out there at the compound. So if somebody falls to the ground from being shot or killing themselves, you're going to see that. And it would be another Perry Morton injury. But the point is that the state's not shown what happened. The state talked about, well, there's mutilation because he chopped her up in all these pieces and scattered her around. No, that's not what the evidence shows. What the evidence shows is that she died, he panicked and went back out there and cremated the body and scattered the ashes. If you're scattering ashes and it doesn't burn all the way through, you're going to see little bits of bone scattered around, which is exactly what you see in this case. Nobody chopped up anybody. Nobody was mutilated. No body was grossly abused. We cremated her, scattered the ashes. Why? Because the police were after him, which of course would be tampering. The state keeps saying a firearm. All you have to know for the special finding is that a firearm was involved. That's not what the actual law is that the court will instruct you on. Say if you find Daniel Stearns committed a second-degree murder or manslaughter, you can also find beyond a reasonable doubt, not simply, oh, I think so, beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened use, or attempted use of a firearm. You should find him guilty of second-degree murder with a firearm. And the state keeps saying that Daniel Stearns shot her in the head. What evidence is there that he shot her in the head versus an accident or her choosing to suicide? None. Point is that in the end, there is an absence of evidence as to what actually happened out at the compound. Defense agrees that he clearly lied to the police because he knows she's dead and he figures she's going to get blamed for it. Defense agrees that he went out there and burned the body, cremated it, and scattered the ashes. That's tampering. Defense does not agree that it is mutilating a body or grossly abusing it, and defense doesn't agree that he killed her. A reasonable doubt can be from the absence of evidence and that he is presumed innocent, and the state must prove with evidence, not assumptions, with evidence, beyond a reasonable doubt that he committed this alleged homicide, and they haven't done it. What happened? You don't know. Therefore, you must return a verdict of not guilty.
Michael, I think we're going to get to the state's rebuttal up next, but I have to ask, I agree, there is no evidence that he shot her. It could have been by her own hand or it could have been an accident. But what is it really like as a defense attorney to have facts that aren't that great for your side, but you've got to get up there and convince a jury of it?
Look, at the end of the day, you have a job to do, and that is to challenge the evidence, right? You try to find something that you have a passion for in the case. And that's what I think he found, this idea that we really don't know what happened. He focused on that. Admitted the guy was there and did some things, but said we really don't know what happened. That's where his passion was coming from. I thought he did a decent job with what he was working on.
I think so, too, and the energy he brought to it, I think he believes it. And he's right? At the end of the day, really. It's the truth. Okay, we are going to take another break. I think that we're going back in for the rebuttal. All right, let's go back in. It should be ready.
This is not a math problem. This is a murder. The evidence that you have, you put it all together. You use your common sense. You look at it all, how it fits with one piece of evidence with the other. What you know is that the victim disappears. She's last seen going to meet the defendant. We talked about some DNA. Well, there's no DNA. Well, you heard from Joseph Kennedy, DNA can't be taken from decomposing flesh. Fire destroys DNA. How hard would it be to wash out the bed of his truck if he was using that to transport her? You don't expect to find her DNA in that truck. He even said UV light can destroy it. So if the truck bed were outside. Look at the actual physical evidence that you have, and you will get to take everything back with you. You'll get an internet-disabled computer. Look at the defendant's cellular report. That does take a while to load, but look at what is actually in his phone. You can watch and listen to the interviews again. Let's talk about what he told Neil Lee and Agent Peterson on March 6th. They say, you guys were friends, right? He said, yeah, like I told the other guys, meaning the Palm Bay police, we had a falling out. We would see each other every now and again. He says, when was the falling out? I wanted to be completely done. This is what the defendant says. I deleted the contacts and everything. When? About a week before the police talked to me last time. We know that's not true because we know he saw her on the 15th. How? A phone call, WhatsApp, or Snapchat. Do you know her number? I deleted it, he says. When they ask, what was the falling out about? Just not clicking, not following boundaries, relationship rules. I don't want someone who goes to see other men. He's explaining his feelings about her right here. The other officers came out on Sunday, February 19th. So when was the last time you saw or had spoken to her? The last time I saw her would have been even longer than that. About a week before the 2/19, you spoke to her, a week and some days. He says his Snapchat is good vibe. You saw that on the records or the site right that was introduced. How do you usually communicate with her? Through WhatsApp and so forth. Did she talk to you about where she was going? No.
We need to squeeze in another break here. Up next, the state wraps up its rebuttal argument, so stay here with us on Court TV Live.
Tonight on Closing Arguments, we're live with the latest and the biggest cases from across the country. Catch up on new developments with insight from our panel of experts.
Closing Arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV.
A wife accused of murdering her prominent attorney husband, and the defense involves blaming her own sons?
Victim to Verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Before we get you back inside the courtroom, let's bring back in criminal defense attorney Silva Megardichian. Silva, thank you for standing by and staying with us. Let me ask you this. How big of a win would it be if there's a conviction, if it is for manslaughter and not for second-degree murder? Because I feel like that's a little bit of where the closing hit, which is to make them think about it, and maybe if nothing else, if it's not an acquittal, which it might be, that it's the manslaughter.
Oh, Judge Ashley, it would be huge. Look, this is the type of case where you say a 4-hour deliberation would be a huge win for the defense attorney. But yeah, a manslaughter conviction by the jury gives honestly a reasonable doubt that the defense argument worked. So absolutely, Judge Ashley, it would be a huge win for the client and for the defense attorney for sure. Anything is better than that second-degree murder conviction.
Yeah, and again, he will face life in prison if he's convicted of that second-degree murder. For me, Silva, the case was won by the medical examiner when they showed that sort of, that visual of those little that's it, the bits and pieces that were left of this once vibrant person. That just, a lot of folks around here, myself, really hit emotionally by that. And then you get that testimony from an anthropologist saying, look, based on what we were able to find, remarkable, they were able to determine that she was shot in the back of the head. I think those two things really wrapped up this case.
Oh, Michael, you know, I was driving to court when the anthropologist actually testified and Court TV showed it, and I was riveted. At first, I was like, God, this is weird having an anthropologist here, but her testimony really showed the heinousness and truly the torturous aspect of this case. If there is a reasonable explanation to this killing, the heinousness of what happened to the body and allegedly what he did to the body really fills in a lot of any kind of existing reasonable doubt as to the second degree, because it's so heinous and so bad that that also is going to linger in the jurors' minds. And I do believe the prosecution did a really beautiful job at highlighting her testimony without detracting from it. It really stood on its own, and it was extremely powerful. And it just shows you, desecrating a body like that, it does show, I think, to any reasonable person, there was some sort of evil intent here. I think that cannot be ignored.
Yeah, I would agree with you. Also, he has been charged, obviously, with mutilation of a dead body, so that is another charge that he is facing. Does it mean anything to you that the plan was for the jury to go home today and start deliberations tomorrow, and the jury came back and said, we'd rather stay and start tonight? So they've now been deliberating almost an hour. And the last little bit of time, does that mean anything to you of what the jury may be thinking?
Yes, absolutely, Judge Ashley. You know, it is incredibly important to listen to what the jury wants. They're exhausted. They've been listening to testimony. They want to start the process now. And I think it also kind of shows us that maybe the jury isn't too far away from actually all agreeing with each other. So it's not a good sign for the defense team that they want to start so fast.
Yeah. All right, fair enough. All right, Silva, stand by. Let's get back in. The state is now wrapping up its rebuttal argument. Let's head back to court.
I described, locked, no more contact. Mr. Fisher says there's no evidence that a firearm was used. Dr. Schmidt and Dr. Walsh-Haney both talked about the exit wound from a bullet. Bullets come out of firearms. So it's true we haven't introduced a firearm. We can't tell you this is the murder weapon, but bullets aren't fired out of anything else except for a firearm. not every case has an eyewitness. Not every case is on video when the crime is being committed. But that's why the standard in a criminal case is beyond all reasonable doubt. Not all possible doubt, okay? You met Dr. Walsh this morning. It's clear she knows what she's talking about. She is an expert in her field. Mr. Fisher was able to get her to concede that it's possible that this or that or the other thing happened. That's not what she thinks happened, and that's not what she told you. Lots of things are possible. It doesn't mean they're reasonable, and it doesn't mean that's what happened in this case. So you will get an instruction that will specifically tell you a reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt should not cause you to return a verdict of not guilty. So I submit to you, that's what the defense is asking you to do. They're asking you to consider, is it possible that somebody else killed her? You don't know of anybody else. I mean, this imaginary DV boyfriend that the defendant keeps trying to push on the police, there's no evidence that person was there that morning. He wants you to speculate that the victim killed herself. There's no evidence that she was suicidal. She went and saw her friend that morning. Her friend said she was looking at other places to live in Palm Bay. They had coffee. She had plans. There's no evidence of that. He wants you to imagine a scenario where she somehow accidentally got shot and the exit wound is out her frontal bone of her skull. And he wants you to force yourself to believe that this defendant lied to the police all those times because he was innocent. You're allowed to use your common sense. How does he know where to go? He panicked, Mr. Fisher says. Panicked from what? What are you talking about? Why does he have to be panicked? How does he know she's dead on the 15th? How does he know exactly where to go? And as far as the grossly abused, you're not going to get a definition of grossly abused, but it means what it means in common language. Grossly abused would mean in a very obvious and unacceptable manner. Mutilated means what you think it is. As far as we're aware, Mr. Stearns is not a licensed mortician. He doesn't have, it's not proper for him to burn a body. You heard Tyler Harrell talk about the banging of the shovel that he kept hearing. You saw those marks in the asphalt. So you're allowed to take all of the evidence that's been presented to you and use your common sense and apply it to the law and the facts in this case. And when you do that and you look at it all together, then you will come back with the only true and just verdict that you could based on this information and find this defendant, Daniel Stearns, guilty of second-degree murder with a firearm, the abuse of a human body, and the tampering with evidence. Thank you.
We will continue to monitor deliberations and bring you the verdict when it happens. Our thanks, of course, to Silva and Megarditchian for joining us tonight.
And that jury's coming up to an hour. Actually, they're on an hour now of deliberations. Now, we're also going to head to Ohio for Court TV's newest live trial, the toddler fatally stabbed trial of Bianca Ellis. She tried to claim insanity in the stabbing death of 4-year-old Julian Wood, but the court found her